All rise. Veuillez vous lever. The International Criminal Court is now in session.
Take those in the indicated time, even if that means going a little past lunchtime. But for now, we will begin with a question that Judge Ibanez has. We'll begin with that, but again, before I call upon her, I will also tell you that at the end of the process, everyone will be given 10 pages maximum to an allowance of 10 pages to make any more written submissions they wish to make on something that has not been submitted upon either in writing or orally that you feel important enough to inform us of or brief us on. The 10 pages for everyone to do that within 2 weeks of her rising. That is it for housekeeping. Now I will invite Judge Ibanez for her question.
Thank you, Mr. President. The question goes to the professors, especially, but if the parties want to address the issue, it's good as well. According to Article 97, what is the object of consultations? Is it to notify or inform the court about a difficult situation faced by a state party that impedes the fulfillment of its cooperation obligations? Or is it to permit the court, after proper consultation proceedings, to decide on the matter? Is it possible for the requested state to resolve by itself the object of the consultation?
While you think about that, while it's processing in the back of the mind, there was one question that has also a related question, I believe, that placed on the table yesterday, where I said whether there are any thoughts that may be expressed on how to improve the process. Again, as I said earlier, at some point, international law is law made workable by a large dose of common sense. The concern is that we mustn't allow that lubricant of common sense to turn into pollutant of essential principles. But in the meantime, let's think about how we can improve the consultation process. I'll add that question on to Judge Ibanez's.
Thank you very much, Mr. President, and Your Honor, for your question. And I'm actually pleased you raised them, because having been one of the drafters of those provisions, Article 97 in particular, I have, of course, posed the question to myself, could we have done better? And I think there is one feature which is crucial and distinct when the provision of Article 97 on cooperation is applied in the context of Article 98. And I think now, after having reflected a long time about this question, I think one has to admit this is not, this distinctive challenge could have been addressed better. Now, speaking from a matter of drafting perfection. The distinctive feature is as such: in the normal situation of cooperation, and this is the perspective from where we drafted Article 97, consultation begins once the request has been issued. There is the request, and then there is consultation. But now, in the context of Article 98, something is very distinct. It is at the moment of the issuance of the request that Article 98 requires the court to exercise its, and I could not have stressed it enough during this week, procedural function. The procedural function to look most carefully to the legal situation in place and to issue the request only if this very court is convinced that it will not place the requested state in a conflict of obligations. So, the court, and I guess as much as, or the more this court clarifies the legal issues, the less this will be a problem. But at the early moment in time of the practice of this court, and we are still in a juvenile period, this court may not yet be in position of all the legal elements. For example, it is not obvious for a chamber sitting quietly without contact to states to know about the 1953 agreement. Just one example to which Jordan has referred.
It can also be a treaty of friendship we don't know about that may get in the way.
I absolutely agree. Mr. President. So here I think what is implicit in Article 98, but which I confess that we should have made explicit in the drafting, is that it is the chamber should feel very free. I would even think it would be a wise course for the pretrial chamber in such a situation to approach a state like Jordan and so proactively and to say, is there anything you would like to wish us to know before we issue the request? This does not mean, and here I fully concur with the prosecution, that there will then be at this moment in time a kind of negotiation process about the law. That is certainly not what those provisions require. But the chamber should make sure at the early stage that it is in full possession of the relevant legal materials as the requested state sees them. And one practical problem then comes into play. We are not here in a situation, this court, prosecution chamber is not in the situation from a practical perspective of an academic seminar, which gives prosecution and chamber all the time of the world at this moment in time already to do a kind of hearing that we have had in this week to really fully exhaust the matters from all directions. It might be for the prosecution a pressing need to go ahead because a visit, for example, of a sitting head's president might only last a little while. So this, and that's another practical suggestion, this shows how useful it is to issue this arrest as early as possible, because this allows even proactively for the chamber concerned to enter into a debate with a requested state of Jordan, which, as we have seen, shows a constructive spirit, and to see and to receive the answer, are there any legal considerations we should be aware of? Of course, then it is the burden on that state to communicate, to fully and honestly communicate. And if this onus is not discharged, this will fall back heavily on this state. But this, I think, should be considered, and that's, I think, precisely the gist of your question, in the future practice of this. Yes, Mr. President.
Can we look at it from the perspective of the state? I mean, you say the negotiation process, or consultation process, should not turn into negotiation about the law. Is it as simple as that, to put it that way? You heard Mr. Robinson yesterday say, look, the matter of asking one state to arrest the head of state of another state is not a small matter. So where one state feels, look, this is a big ask of us, and we're not sure that the law allows us to do this, how's it supposed to work out in this consultation process?
Yeah. I would agree, both with my learned friend and with what is implicit in your question, that this space of dialogue between the court and the requested state concerned is also a moment of time, certainly not of negotiations, that's not the issue, but a moment for the chamber, the prosecution, to pause and to reflect on, and you mentioned the term, Mr. President, the policy consideration of, for example, Mr. Darrell is saying, is this an essential contact? This key word, and Mr. Robinson used that word wisely and deliberately and sensitively for what has actually been happening in the Assembly of States parties. So it was not, so to speak, just his invention, these words. So it could give room to the court to exercise what I would call discretion, whether this is a moment where one should insist on what I believe is the law, or whether it is perhaps in this specific moment wiser not to do it in recognition of considerations which I do not, and I will of course explain that again in my observations, which I do not consider as legally compelling, but which may have political merit.
Thank you very much, Mr. Christ. Yes, Mr. Ruston.
Thank you, Your Honour. I don't want to go before any of my academic colleagues, but as the question was also addressed in invitation to the parties, I just wanted to offer one or two additional thoughts. So certainly turning to Article 97, it is, and paragraph C, it is of course of general application, not only to Article 98. One can imagine that these questions may also arise in other contexts. So for example, in Article 90, dealing with competing requests for extradition, there may be, again, a situation of horizontal obligations which may be necessary for the court to be aware of. While indeed Article 97C can be also a vehicle for addressing those questions which may be relevant for an Article 98 determination, and we don't discount that, I think it's also instructive to examine how the pretrial chamber examined the relationship of 97 to 98, but also to Rule 195. Of course, Rule 195 is, if you like, lex specialis to 98 and consultation, because it is the specific rule that was adopted to implement, to give effect to Article 98. And that's why the pretrial chamber first proceeded to examine it under that heading, and then came back and said, well, in any event, we can also then examine 97, because 97 is the provision that was notified to South Africa in the initial context, and in this case to Jordan. And so just in terms of coming back to 97, of course, the context of raising consultations with the court is to identify problems which may impede or prevent the execution of the request, to consult with the court without delay, and critically, in order to resolve the matter. So the object is to resolve the matter one way or the other, to come to a conclusion of whether or not, in this case, for example, the request might need to be modified, the request might have to be withdrawn, or the request could proceed or should proceed in the manner as originally sent. And then looking at 195, I think this is highly instructive. 195 in paragraph 1 clarifies that when the requested state receives a request for surrender from the court, and it identifies a problem within the scope of Article 98, the requested state shall provide any relevant information to the court to assist the court in the application of Article 1 or Article 98. So the critical aspect there, which the pretrial chamber emphasized in both the South Africa and Jordan decisions, is that while the state, of course, is encouraged to provide such information, fundamentally it's for the court to apply Article 198. There is no process of, I know this is not in Jordan submissions, but in the context of South Africa, where this issue was discussed, there was a suggestion that there was a process of consultation which involves some to and fro and coming to some kind of mediated solution and agreement or consensus or even negotiation of what the obligations of South Africa might be. And the court said that's not the case. It's not that type of consultation. It's not a political negotiation or negotiation over the meaning of the terms between the state and the court. The state will provide the information to the chamber, and the chamber will then apply Article 98 because, of course, Article 98 directs itself to the court. The court may not proceed with the request. And then finally, on this question indeed, as Professor Kress mentioned, of the short window that may arise in the context of an opportunity to execute a request for arrest and surrender. Again, this doesn't arise from the facts here, but Your Honor raised the question. I think it is also instructive, again, to look at what had happened in the South Africa context, where at the domestic level, when seeking to execute and implement the request for arrest and surrender, the initial order that was given by the domestic authorities, by the domestic court, was an interim injunction barring Mr. Bashir leaving the territory, not to take him into custody, but to restrict his liberty only to the extent of not allowing him to leave the territory until this matter was resolved. And of course, this is typically how it works in extradition practice. When, for example, Augusto Pinochet was prevented from leaving the United Kingdom, he was not placed in custody, but he was restricted from leaving until the litigation resolved itself. The same thing happens quite frequently in extradition practice. Sometimes these are very high-profile cases, such as recently in respect of extradition requests from, for example, Serbia, objected to by Kosovo, and so on. But this may also give an analogy that's of interest to us. And in that context, it's interesting to note that Article 98 only says the court may not proceed with the request for surrender. It doesn't say the court may not proceed with the request for arrest. And coming back to what it says, indeed in Article 89, states are under, it would appear, an absolute obligation to arrest. And then maybe the court can't proceed with the rest of it until hearing what the objections are, having the consultation with the relevant state, and then either agreeing that the person should be allowed to return back to their own territory, or that they should remain because this issue needs to be resolved, or that having resolved it, the person should be surrendered to the court. Now, we had raised these issues in our pleadings in South Africa. The pretrial chamber in its decision didn't find that to be necessary or in fact found to the contrary, found that a request for surrender that the court cannot proceed with must also include the arrest aspect of it. But just to note, because it was raised here, that this is one aspect that may also assist in how the court practically deals with consultations to fully ventilate them in complex matters without having to necessarily be bound by the few hours where there is an arrest opportunity and so on. Thank you, Your Honor. I think,
So would
yeah,
you listening to both Mr. Kress and Mr. Robinson speak on this matter, Mr. Ruston, is it possible, really, if you can forgive the analogy, is it possible to look at this? I mean, if you looked at, when you see two people who know how to dance tango, it's a beautiful thing to see those who do it well. But underlying it is all kinds of subtle communication between them. Should we go this way or not? So, okay, don't go that way. If you go that way, I'll not go with you. That sort of thing. It's a subtle, quick thing that goes on and it works out very well. Isn't it somehow, when it all boils down, how this thing should be played out, considering that analogy of the, I don't like to use the word giant, but somebody put it on the table, whatever it is, without legs.
So my wife would certainly understand the analogy, being Colombian and myself not being very adept to the rhythms. But for sure, to resolve the consultations, the court and the state must understand the context in which they're negotiating or sort of consulting, and the relevant norms that apply. And ideally, this should be a process that can be resolved rapidly indeed. There is this emphasis throughout Part 9, and particularly also in the provisions that we discussed, that the resolution should be reached without delay. And of course, restricting the liberty of anybody, particularly if they should not have been, should not be surrendered, is something that should be resolved early. Even more so when the stakes are so high, when we're talking about somebody enjoying head of state immunity. And the court, of course, is grappling with this issue for, let's say, the first or second time in terms of a state coming back and consulting, so it is still early. But I think it is relevant to go back to, nonetheless, the ordinary meaning of the terms, object, purpose, read in the context and so on, which are very clear in terms of what is the purpose of this consultation. It is not a procedure to raise objections or refusals or reservations. Any information that's raised is done with a purpose to resolve the matter within the procedure, the dispute settlement procedure, if you like, that has been agreed to by state parties when joining the statute. And that dispute resolution mechanism foresees that it is the chamber that will decide, not the state. The state will not have the opportunity to bilaterally refuse or unilaterally, refuse the request because it has a different opinion. And this, again, this is one of the things that was raised in the South Africa context, but that it is ultimately for the chamber to resolve that dispute, and the state has to accept the authority of the court to make that ruling. Now, of course, the state can appeal it, but in the first instance, the state cannot simply say, well, we've heard your decision, we've heard your call that arrest and surrender must be effected, that it has no suspensive effect. We've heard all that, but we still disagree. We still think that immunity applies. Therefore, we will not comply.
So then there are two things there. First of all, the matter of the law, some may look at it as something that comes in as a matter of last resort when you've tried everything else and you feel really that you have to go to the letter of the law. If it's necessary to do that, that gets done. But there may be instances where communication may well avoid that incidence of last resorts and say, okay, do we really need to push it to that limit, or is it something we can resolve without having to get to the letter and spirit of the law question? That is one. And the second question that occurred from your last intervention said, of course, it may well be that the state may appeal. Is this something that is envisaged within the process of 97 to the extent that it may cross over to 98? So if there's disagreement in the context of the consultation on the question of law, so there will be a quick mechanism, perhaps an expedited process of appealing it, as one would do in certain domestic instances where you have extraordinary right of appeal quickly on some things.
Yes. So, I mean, first of all, I think, thank you, Ron, for the questions. And again, maybe the professor, particularly Professor Kress and others, may be better suited. But I think the letter and spirit of the law is not I would submit, a last consideration. It's the first, it's the primary, it's the totality of considerations that apply. And the scope for consultations is not to take into consideration, I would submit, extra-legal considerations that are outside of the scope of the statute, but to give effect to those very provisions of the statute that require considerations of specificity, relevance, and necessity to be made out before a request is put to a state and the state executes it. These are the three principles that are recalled in the case law of the court, of course, in relation to requests for assistance. Those principles of relevance, specificity, and necessity are reflected in Article 96.
One would think that in matters of every litigation, it is always possible for parties to, this is a question to you, to reserve their rights, their legal rights, until they really have to assert it.
Yes, what I only mean is that the consultation procedure here that, for example, allows a state to bring additional information to the court and so on, is of course to be read in the context of other provisions that specify throughout Part 9 that there may be circumstances where the state says they're not refusing the request, because under Part 9, of course, there's no scope for refusal as such. But perhaps one can make the exception for Article 72, which talks about denial of a request, but even that triggers a separate procedure. So there's no scope for refusal as such, but there is much scope for a state to come back and say that the request in its current form can't be executed because domestic law doesn't envisage it, or that the request is unclear, it's too broad, it's not specific, the relevance has not been made out, or, for example, the request for the coercive measure is not necessary because this can be obtained through another mechanism, and so on. So all of these form vital aspects that are within the legal considerations, and they may be capable of resolution by consultation with the state and the court to resolve the matter. It may be a technical matter in terms of a lack of clarity of the information. It may be an operational matter because of the form in which the request is requested, or then it may be also a fundamental problem in terms of the law itself, a fundamental legal principle, and so on. So all of these considerations are within the statutory scheme and are open for resolution. So I think when we are at the Article 98 stage, we can't go really beyond those mechanisms that are already within the scheme. I don't know if that answers your honest question.
Yes, thank you very much. Professor Lutanzi, please.
Merci, Monsieur le Président. La juge Ibanez nous demandait surtout quel est l'objet des consultations. Donc, je voudrais seulement brièvement répondre à cet aspect de la question. L'objet, naturellement, ce ne sont pas les règles à appliquer. Les règles sont là. Sur la base de l'article 98, la Chambre est le dominus pour lire le rapport, déterminer le rapport entre le 27 et le 98. Et donc, les consultations sont surtout prévues, selon moi, dans un rapport naturellement dialectique pour que à la Chambre soient fournies toutes les informations sur l'existence de ce que vous avez donné comme exemple, de quelques obligations par un accord international qui n'est pas à la connaissance de la Chambre et qui pourrait représenter un conflit d'obligations. Mais le problème du conflit des obligations par rapport à l'applicabilité de l'article 27 pour un État que la Chambre aura déjà déterminé qu'est un État obligé par le statut, cela, selon moi, ne peut pas être objet des consultations. Il y a pour l'État le respect de la présomption de la fonction de la Chambre dans l'interprétation des règles du statut.
Yes, Mr. Murphy and then Mr. O'Keefe.
Thank you, Mr. President. Judge Ibanez asks a very important question, and we welcome the opportunity to speak to it. In our view, Article 98 of the statute says the court may not proceed with a request until certain things have happened. The request, in our view, should not have even been made to Jordan without first at least considering that if you're directing the request in the context of a summit of a regional organization, it is inevitable that there will be Article 98 issues at hand. And consequently, that's the manner in which the starting point of the request should have occurred. Professor Kress says we didn't really, when we were negotiating 97 and 98, think about this. I don't know if he's speaking in his personal capacity or as a former delegate for the government of Germany or what. If it's the latter, perhaps we could put him on the stand over there and ask him a few questions. But the point is, in our view,
there have been others who have given us their own views of what happened during negotiations. We did not put them on the stand. So.
Fair enough, Mr. President. It was a mere debating point, really. But in our view, it makes sense as written. The court should be satisfying itself. Now, it's understood that perhaps the court's not aware of the exact treaties that exist with relate to these summits. That's an opportunity for the court to approach a state party before launching the request to engage in this kind of dialectic, if you will. But even if we set that aside and say that the court can launch a request in a context such as this without attempting to satisfy itself as to what possible impediments might exist that would trigger Article 98, once you get to Article 97, and this is Judge Ibanez's question, to us it's clear that it is saying the purpose of the consultations are to resolve the matter. That means not just the state party saying we have a difficulty, we accept that. It means that it is a dialectic between the court and the state party to talk through the issue. As you put it, Mr. President, ideally it's some form of a tango. We would submit that we showed up at the dance and no one asked us to tango. In our view, it needs to be a conversation between the two sides. And if you're asking for how might one improve this matter, we would say that the court should be diligent if it does launch a request about being in contact with the party, perhaps requesting a meeting if there's some fear that there's delay here that needs to be addressed, perhaps setting up a meeting with the parties, as was done in the context of South Africa. Perhaps trying to talk through, you say that there's a head of state immunity. In our view, Article 27 has this effect on 98. The reason why the Council's resolution, even though it doesn't say anything about immunity, is best interpreted as doing the following. All of that is a part of that conversation, that discussion. And again, I know you're talking about this in the broader context, but we really do feel in our context, it was not Jordan's fault that this conversation did not move forward.
Mr. O'Keefe first, and then Mr. Jando.
Mr. President, I had been wondering how sitting down all day you maintain your svelte physique, but now I hear the dulcet tones of Astor Piazzolla. I can picture you in the smoky bars of San Telmo in Buenos Aires. A point of information on what Mr. Raston said, and it's not to rebut it or anything, because it seems to me that's not the idea of this particular part of the hearing, but to assist in trying to develop recommendations as to what might happen. Just a point of information, it's absolutely clear under the law of immunity that a restraining order is a violation of immunity, in the same way that an order to testify in anyone's proceedings, but a mere compulsory order to testify, as made clear in the International Court of Justice case of mutual assistance in criminal matters, and as made clear in the Vienna Convention on Diplomatic Relations, is in and of itself a violation of immunity, let alone handling the person, arresting the person, which is a violation of inviolability. On that latter point, I think the court should be hesitant to separate, in the context of Article 98, immunity from inviolability. I thought we're acting under the assumption here that Article 98 covers the both of them. And so I think a recommendation along the lines of, well, let's violate immunity or let's violate inviolability and then decide whether to violate immunity and inviolability, it seems to me is not a workable way forward. There would have to be some other way which didn't prejudice the rights of all concerned.
Mr. Jando.
Thank you, Your Honors. Good morning. I just wanted to take the floor after listening to the conversation to maybe make 3 points. It struck me as very interesting to hear Mr. Kress explain about the drafting challenges, and then further on, Mr. Rastan picking up the more practical sides, the challenges that have been posed for the court in terms of dealing with what 97 means in practice. And of course, Judge Ibanez has raised an important issue that I think, and Mr. Kress is of course in a better position to share the logic at the time, but it seems to me 97 and 98 are essentially twin provisions. Twin provisions in the sense that 97 places a burden on the state, and 98 places a burden on the court. And when you look at 97, it essentially says, you, the state, identify the problem and tell the court what those problems are. And then it goes on, as your honors know, to give the examples of the kinds of problems that a state might be facing that could prevent it from meeting a request from the court. Those types of problems strike me as very interesting because in many ways they assume the good faith on the part of that state, right? The state is trying to help the court to resolve the issue so we can kind of move forward. I'm not talking now specifically to this case. I'm wanting to just step back, as your honors invited, to make a broader observation. So those examples are good because you are trying to solve the problem. And then when you tell us what the problems are, we could then, after we've gone through this consultation process, we will then be in the place with all the information in hand by the time we get to 98 to decide not to put you in that place of difficulty. Now, I wondered whether in the discussions at Rome, and maybe now at the policy level, because this is very much a policy discussion, what that might mean for the court. What about the situations where the state may not be trying to assist the court? Or what about situations where the state may actually have genuine impediments, but they may appear to be bad faith in terms of, if you think about saying, well, insufficient
May even be a matter of communication.
Exactly,
and something in a hurry, but
exactly, and your honors, there's also that without delay element to it. But think about the complexity of the state. So there may well be, if you think about time, this request goes to the executive branch, but a ruling may have to be made, if you think about Mr. Ratstan's point, by the courts in the national system, because there's a problem with the request. That doesn't, that moves in a system of the rule of law in its own way, depending on the country that is at issue. So in a sense, you could then find yourself, and the court may well be in this position, where it may appear that the state is stalling, not acting in good faith, but in fact, there might be other things going on at the national level. So it's very, very interesting as a challenge in the sense of what it then could mean for the court's decision under Article 98, because you have that potential difficulty. So I would just end with there was a second point, there's a very brief point, which basically then says, in my mind, at least it's a question for the court to consider. In the context of South Africa, if I recall correctly, South Africa had a view as to what the consultation process was. And in the Sheba's commentary to the Rome Statute, he describes in a very sort of succinct way how that went in the discussions. Essentially, South Africa was told, yeah, we already resolved that problem. And going back to Mr. Murphy's point, they disagreed that the problem had been resolved at the level of the consultation with the embassy, and of course others here may have been even part of those discussions, but the way he portrays it based on the decision of the chamber was, South Africa was basically told, well, your problems are not real problems, but of course we are here precisely because they had a different view essentially by the time you get to 98, because then the court essentially ignored those concerns raised by the ambassador, I believe, in what they thought should be the consultation, that's a two-part, and then got that request, and of course we had a decision. So just the final point might be then, at the policy level, could this then be an issue perhaps for the rules of procedure process or the ASP, perhaps, in terms of policy for the court? Thank you, Your Honors.
Do you also consider, Mr. Jallo, that in all of this, you talked about some things may appear as stalling, well, they may not be. Of course, quite apart from, and this point I make here doesn't have to relate to this case. As we know, we're saying, how can we improve the system beyond the specifics of this particular case? That in mind, is there a sense in which you may be taking into account whether or not there are systems there's an assumption the systems work the same in every country.
Of the, oh, sorry, the mic was off. I apologize. So, Your Honors, I was just saying that was a great point that you raised, and I've had the privilege of being in the Crimes Against Humanity and War Crimes section of the Justice Department in Ottawa, where the responsibility of the office is essentially now to implement what will be the Crimes Against Humanity Act, incorporating the Rome Statute in Canadian law. And we were dealing with cases, Your Honors, in diverse settings of individuals who've come to Canada who are accused of being involved with international crimes in all the different regions, and it required rogatory commissions in some instances, so we'll have to travel to fulfill the obligations under the Canadian Charter of Rights and Freedoms in terms of Canadian law with judges to certain parts of the world, if you think about former Yugoslavia. And there was a very complicated process at in the national system, and this is a very, very developed country. It's a country that's going very far, doing a great job in trying to fulfill its obligations. So the requests take a long time, because the office that is carrying out the investigation has to rely on what they call the International Assistance Group. So we send the request there depending on the issue, and then it goes to the straight to other state through the diplomatic channel. A trip is then made. I mean, it takes months, if you will. That's the point I'm trying to make. If you switch to the African continent, we had cases coming from Rwanda. Some of them matured, like in Muneniza and so on, to actual prosecutions. They take a lot of time. But there's another element, Your Honor. It's very expensive as well. And there's another element from the point of view of the receiving state, the state receiving the request. A lot of these countries, and with all due respect, I'm coming from the Africa region, they may face challenges that are very genuine. And this is where the work is happening in terms of the ICC. So when you think of those states and you say, well, how you're not responding fast enough? Well, it may be that there's no one to deal with the request. It may be that we don't have the resources to even respond, and we're trying to figure that out. So it is a complicated issue, Your Honors, and my sense is an area where, because the practice is very early, that the court could be very deliberative, and perhaps at the policy level have some thinking done. I think it's more a matter for the rules, perhaps. Thank you, Your Honors.
Thank you very much. Yes, Mr. Raston, back to you.
All right, I won't be very long. Just to come back on a few questions of the issues that are raised, and then your question of recommendations. Now, in terms of your tango analogy, you have been reminded that, of course, while it does take two to dance, one needs to lead. One of the two needs to lead. And of course, in this instance, we believe that it is, in Article 98, the nature of it, that the court leads. And in the South Africa conference, indeed, I was involved in that. And the issue that was engaged there, I know it's not in dispute here, is that, yes, South Africa did raise an impediment. They raised a legal impediment, which in that case was they believe that head of state immunity prevented them to proceed. And then in the consultation that happened, although on an expedited basis, nonetheless, the court recalled its jurisprudence on the matter and said, but this legal objection has already been resolved in the case law. Therefore, that's why we ask you to proceed with the request. It wasn't that it was merely ignored, it's that the court took a position, but South Africa disagreed with that, and we know, of course, how it ultimately played out. Now, in terms of the very good point that Mr. O'Keefe raised, yes, of course, there are considerations of inviolability which would be potentially breached by the mere fact of restricting the movement of a person who enjoys immunity. But that is actually how it works in extradition practice. In the Pinochet case, it was functional immunities, but notwithstanding, while the courts heard whether or not functional immunities would avail him, they nonetheless restrained him. Now, I know we're talking about head of state immunity, but in South Africa, again, the high courts, notwithstanding that the mere barring his departure from the territory of South Africa could have been considered to be a breach of his fundamental inviolability or the full scope of the personal immunities that he enjoyed. Nonetheless, the interim injunction was given that pending resolution of this issue, he should not be allowed to leave. And of course, we get then into a catch-22. If a court that seized of a request for extradition, or in our case, even more clearly surrender, can never even get to the question because the person has already left, then you get into a strange scenario. And I think in that context, it's important to make, again, this distinction between the international and national. At the national level, even the mere issuance of the warrant is already breaching the rule on personal immunities. That's according to the ICJ, of course, in the arrest warrant decision. Whereas it's never been suggested, certainly not even here, in terms of the vertical effect of of Article 27, I think all parties accept, that the court is entitled to issue a warrant. So it is then distinguishable from the national process. And then the question is, well, what other aspects are also distinguishable? And certainly we would say at the minimum, it can't be that the court can't even ask for the person to be held pending the resolution of the issue. Now, this is not, of course, the heart of our submissions or what's on appeal, but in terms of policy recommendation and all the rest, I think all of this goes to the question of how this might be dealt with. And your question of whether or not the court could do this on an expedited basis, well, of course, we can also look to other provisions of the statute that deal with similar types of disputes. For example, in Article 90, in paragraph 3, when dealing with a request for competing requests for extradition and surrender, there it also directs the court to, if necessary, make a determination on an expedited basis. And then if we looked at Article 97,
the point is not about really, the point is not so much dealing with it on an expedited basis as it is about resolving it on an expedited basis, including any question of law that's getting in the way, resolving it by way of appealing it and getting quickly more or less a definitive answer to it.
Yes, Your Honor, that could be a possibility, but of course resolving it in the context of dispute resolution is of course the function of the chamber. So whether it's first instance and then a second instance, and of course the appeal, even if it was within the procedure, would not have suspensive effect, of course, unless ordered by the appeals chamber. So the resolution of the issue is directed to the court. Of course, the parties, the state concerned receiving their cooperation request engages in the process of consultation, but the resolution is not done jointly by consensus. It is the court that then will ultimately make a determination on how this issue should be resolved, particularly when there's a legal question.
But if the state concerned said, well, pre-trial chamber, yes, you answered this question, legal question, to the best of your ability, and we accept it in good faith, we're just not reassured, and we would like to appeal that point as to get some definitive answer on it. Is it something that makes sense, although it may not be precisely provided for in the statute? I don't think it does, but it is something to think of.
Of course, we have the different routes for appeal, and of course under 821D, if it would materially assist in the resolution of the matter, one could imagine that that might be potentially something that could be appealable. That would be obviously something that would have to be determined by the relevant chamber. But again, the aspect of whether or not that would have suspensive effect, what would be the meaning of such a procedure if the person has already left the territory. The case law of the court that also says that when a matter is being dealt with by the court, the state must not take efforts or steps that would frustrate the ultimate outcome of that decision, that would preempt it. That was in the context of admissibility decisions, if I recall. So allowing the person to depart the territory of that state before this issue has been resolved would then frustrate the purpose of seeking such resolution or final appeal. But I just wanted to come back also, Your Honor's suggestion in Article 97, can we think of recommendations, how to improve it and all the rest? Of course, we can recall that there was a process that was triggered at the ASP, indeed by South Africa. I think it's experience with the initial procedure that led to a working group being set up by the ASP. This working group spent about a year and a half to look at the question of whether or not the procedures, particularly in Article 97C consultations, could be improved. And they submitted a recommendation to the Bureau. That was adopted. This is Resolution ASP 16/Resolution 3. And those understandings which are adopted are there for the record. And the important aspects I just wanted to emphasize is that it emphasizes in the last three paragraphs of that understanding that neither the request for consultations, nor any outcome of the consultations has suspensive effect unless a competent chamber so orders, that all of these understandings are without prejudice to the independence of the chamber and the need for the consultations to be conducted in accordance with Article 97, and of course that they have to be interpreted, of course, in line with the statute and rules. So these are the consultation understandings that were adopted by the state parties themselves. Now, obviously, the first part talks about the technical procedure of how a request for consultation is made, where is it channeled to, who are the different actors involved. But I think it's important to recall that this process has been ventilated at quite some length in that working group. So while Your Honours could, of course, suggest some other recommendations, one should not ignore
Mr.
that.
Ruston, we're aware of those recommendations from the ASB. Whether or not that resolves all the concerns we are talking about here is a different question. But we're aware of the ASB resolution. All right, why don't we move on then to other matters? Now we will begin with our final observations. According to the schedule, the AU goes first. Yes. 40 minutes. 40 minutes.
Thank you, Your Honor. Mr. President, members of the Chamber, it is my honor to present the closing statement of the African Union. In this regard, I would like to thank Your Honors for the extra time, but I don't intend to delve extensively into what we have already exhausted in our statements. Allow me, before addressing the legal issues, to make a few general remarks. The African Union does not encourage impunity. As explained previously and described fully in our written submissions, the African Union has adopted policies and instruments to hold the perpetrators of egregious violations of international criminal law and breaches of norms of jus cogens accountable. However, the fight against impunity has to be taken up within the parameters of the rule of law and without threatening the stability of international relations. The rule of law will be greatly prejudiced if, as has been the case, the appeals chamber follows the à la carte and shifting sands approach, in which any legal theory works as long as the outcome is there should be a duty to arrest Mr. Bashir. The rules of international law, which have been reflected in the Rome Statute, make it clear that heads of state are immune from the exercise of foreign jurisdiction under Article 98. It is equally clear that there are no exceptions from this basic rule. We cannot agree with the interpretation that this court, in addressing the matter before, it should be confined only to the Rome Statute. The Rome Statute is a treaty that was adopted in an existing legal system, and it cannot be studied and interpreted in the abstract. There was no legal void with regard to immunities as a right and as part of customary international law before and after the Rome Statute. We are before conflicting legal obligations on states parties to the ICC. And although we heard the call that this court should set the hierarchy between these obligations, in our view, with all due respect, this is not the job of this court to decide for the international community which treaty obligation overrides the other, or which comes first. This will have a serious consequences on the work of this court and will create further confusion among members of the international community. As extensively detailed by my colleague, Professor Tladi, the referral by the Security Council to the ICC doesn't put a state non-party to the Rome Statute analogous to a state party. In fact, as complex as this issue is, in our view, this will be an end to fundamentals of international law, which is the right of a state based on its sovereignty to express its consent to be bound. Otherwise, consequences will be faced with a new legal system that we are yet to discover. State practice, bilaterally and within international organizations, together with international jurisprudence, proved that it is a legal obligation to honor immunities bestowed by states to her agents, senior officials, and heads of state, with no exceptions. I want to emphasize that the reflection of this general rule is that all states, and not some states, have unanimously affirmed that under international law, there are no exceptions for immunity from foreign criminal jurisdiction. Here, I'm not speaking of African states, but all states. States from Europe, the Americas, Asia, and Africa. I mean all states. The only four that have held otherwise are the various pretrial chambers of the ICC. Surely, Mr. President, it cannot be that the whole world except the ICC is wrong. We have heard the argument that when a state acts in cooperation with the court, it is not the state acting, but rather the court is acting through the state. That is to say, the state is an instrument of the court. We will refer to Article 4.2 of the statute, which provides that the court may exercise its functions and powers as provided in this statute on the territory of any state party. Yet, on a plain reading of this text, it only refers to cases where the court exercises functions and not where the state itself exercises the function. Moreover, in accordance with Articles 2 and 4 of the draft articles on state responsibility, it is obvious that the conduct by any state organ is attributable to this state. Our position is clear with regard to the distinction between Articles 27 and 98 of the Rome Statute. The first addresses clearly a procedural matter in relation to jurisdiction, and addresses the obligations of states parties towards their other international obligations. The real question is whether Jordan or the visited African states that are party to the Rome Statute have violated their obligations under this statute by not arresting and surrendering President al-Bashir to the court. Moreover, none of these states that President al-Bashir visited stood before this court to contest the applicability of Article 27, because that is not the point in these proceedings. It is true that the treaty should be read in its entirety, but that should not ignore the fact that when we interpret a treaty, we need to consider the object and purpose of every provision therein. Moreover, the call that Article 27 denies states parties to the statute the application of immunities towards third states, then one wonders, why do we have Article 98 in the same statute? Your Honor, the Rome Statute was adopted to fight impunity in genocide, crimes against humanity, and others. It was not adopted to break the current international legal system. We are of the view that the intention of the drafters of the Rome Statute was very clear. For the sake of justice, and in case of failure by a state to prosecute perpetrators in the most heinous crimes, an international court may take this job, while at the same time taking into consideration that this court will not in any way hamper international peace and security or be used as a political tool to initiate vendettas between political rivals. Article 98 addressed specifically the legal obligations of states outside the Rome Statute context. In particular, it addresses the legal obligations of states relating to immunities and customary international law. This was not done haphazardly. This was the outcome of intensive negotiations, knowing that the issue of immunities and waiver may create situations that may threaten peace and security in the world. The Rome Statute itself has acknowledged in Article 98 the existence of immunities of state officials. Furthermore, at this point, we can just pause for a moment to ask a question. On behalf of Jordan and African states that President al-Bashir visited during summits, if the arrest had taken place, what would have been the consequences on the relations between Jordan, those African states, and Sudan? Have we considered at any point that not honoring the immunities to a sitting head of state may lead to political and possible military fallout, destabilizing regions in the world? In our view, the Rome Statute took that into consideration when it was adopted with Article 98. So the entire week's debate against the right to immunity is, in our view, redundant. This, of course, is a policy argument, and the ICC should be guided not by policy arguments, but by the law. But this policy argument is precisely the reason why states are willing to contemplate the possibility of exceptions to immunity, rationa materiae, but are all strongly opposed to exceptions to immunity, rationa personae. In this regard, we are positive that this esteemed court will find an appropriate remedy respecting the rule of law rather than serving political and policy objectives. Mr. President, members of the Chamber, one of the arguments that has been used to justify the shifting sands approach of the pretrial chamber is that any other approach would disable the court and make it less effective. This is a red herring that is not borne out empirically by the experience of the ICC. Since it officially began its operations in 2002, the ICC has indicted more than 40 individuals. Only one of these cases would be affected by the African Union argument. In our view, it is the interpretation of the Rome Statute advanced by Pretrial Chamber 2 in the DRC, South Africa, and the Jordan decisions that would, at least for future cases, significantly affect the reach of the court. Those decisions limit the applicability of Article 27 to states parties, save for the rare circumstances where there is a Security Council resolution. It should be recalled that under the interpretation advanced by the pretrial chamber, the ICC itself would be barred, notwithstanding Article 27, from exercising jurisdiction over any official of a non-state party. It is against this background, members of the chambers, that the African Union submits to you the following. One, there is under international law, as it currently stands, no exception to immunity rationa personae from foreign criminal jurisdiction, which Mr. al-Bashir has by virtue of being the head of state of Sudan. The appeals chamber has been provided with no state practice nor international jurisprudence to suggest that in cases relating to proceedings before an international tribunal, there are exceptions to this immunity to enable arrest and surrender to the international court concerned. Without such practice or jurisprudence, the chamber should hold that there are no exceptions to the fundamental rule of international law on the immunity of state officials. Two, we pray that chamber will hold that the UN Security Council Resolution 1593 does not waive the immunity of Mr. al-Bashir. In our view, any expansion in the interpretation of the Security Council resolutions, especially under Chapter 7, will lead to severe ramifications in international relations. Otherwise, many illegal actions of use of force could be deemed legal by implication. Our submission is that this court should accept that Security Council resolutions are subject to extensive negotiations before their adoption. Hence, the intent of the drafters of Resolution 1593 is what is reflected in its expressed language. That is to say, no waiver to the immunities. 3, we pray that the court rejects the fiction that a referral under Article 13b places a state that is not a party to the Rome Statute in a situation analogous to that of a state party. There is nothing in any means of interpretation that has been advanced to justify that conclusion. Nothing except the political and policy objective to which I referred earlier. Indeed, quite apart from the absence of anything to justify the fiction, the conclusion that Article 13b has any effect on immunities of a state that is not a party to the Rome Statute is flawed for at least 2 reasons. It ignores that the conferral of jurisdiction does not itself remove immunity. Indeed, immunity presupposes the existence of jurisdiction. So the mere fact that the ICC is granted jurisdiction does not remove immunity. To the extent that this fiction is based on the notion that an Article 13b referral requires the whole statute to be applicable to the situation, the whole statute includes Article 98. Your Honors, finally, you have been presented with interesting theoretical arguments that have no basis in law and should be rejected outright. These include, contrary to its Article 6, the proposition that the Genocide Convention amounts to a waiver of immunity by Sudan, and that through the controversial abuse of rights doctrine, the immunity owed to Mr. al-Bashir should be considered. As a court of law and not a populist institution, the ICC should allow legal rules to constrain it. This includes legal rules that might affect its policy objectives. That is what is meant to respect and promote the rule of law. It is our hope that this appeals chamber will lead by example and allow those legal rules to constrain it. On this basis, we pray that the appeals chamber will find that by virtue of the operation of the Rome Statute and customary international law, there is no duty to arrest Mr. al-Bashir. And I thank you.
Thank you very much, Ambassador. We will now go next to the scholars, the legal scholars. In alphabetical order, we will begin with Mr. Kress. 25 minutes is your time. You don't have to use it all up.
Your Honors, please allow me to introduce this statement by recalling an instance of state practice from around the hour of birth of modern international criminal law. For the specific reference, I refer to paragraph 283 of the Reasons of 5 April 2016 of Judge Eboe Ozuyi in the case against Ruto and Sang. Confronted with the American idea to put the major German war criminals to trial, British lawyers produced an aide-memoire which was handed over to the United States on 23 April 1945. In this aide-memoire, the British observed that, I quote, "It would be manifestly impossible to punish war criminals of a lower grade by a capital sentence pronounced by a military court, unless the ringleaders are dealt with equal severity. The reference to the ringleaders explicitly included Hitler, who at this moment in time was believed to be alive and in office. This statement demonstrates what is at stake when the appeals chamber of the first permanent international court, International Criminal Court in legal history, will for the first time squarely address the question of immunity of sitting heads of state in proceedings before it. It has been said in the course of this hearing that it constitutes a momentous decision for a state to arrest and surrender the sitting head of state of another state. This is undeniably true. But the British aide-mémoire makes it clear why it constitutes in turn a momentous impediment to the enforcement of the jus puniendi of the international community when a sitting head of state enjoys immunity from criminal proceedings before the competent international criminal court. The reason, quite simply, is this. The sitting head of state will often be the ringleader, or to use the now accepted term of art, the person most responsible for the commission of crimes under international law. The British lawyers, guided by their fine sense of justice, saw the problem at their time. It would no doubt pose a fundamental problem of legitimacy to punish the low-ranking recipients of criminal orders while sparing the masterminds behind the entire criminal system. In these hearings, Jordan has repeatedly tried to diminish this basic legitimacy problem by placing emphasis on the difference between immunity and impunity. From a technical legal perspective, Jordan's point is, of course, impeccable. But Jordan's perspective misses that crucial point of legitimacy. During the week, we have more than once been referred to the possibility to see President al-Bashir walking into this room out of his free will. Had I made the argument, I would no doubt have been given a gentle smile. Here speaks the ivory tower of academia, one would have said. But the same argument does not become less detached from historical experience and current practice when advanced by state councils. To put the point in the clearest possible terms, the risk that immunity will result in impunity is all too real in practice. During this hearing, two legal avenues have been discussed: the customary law avenue and the Security Council avenue. From the angle of the basic point of legitimacy underlying the British aide-mémoire, the customary law avenue and the Security Council avenue differ considerably. Let us be realistic. The Security Council avenue does not carry us very far. If we look to the foreseeable future, the prospects for a consistent practice of Security Council referrals are slim. What is more, sadly, the practice of the Council subsequent to the referral of the situation of Darfur has shown how little this body is a reliable partner to the court. Again, the prospects for a change of direction in the Council's practice are less than overwhelming. Thus, only the customary law avenue allows the court to exercise its limited jurisdiction over nationals of non-state parties in a manner that will not all too often spare the ringleaders. This is why I wished to explain to the Chamber my conviction that pre-trial Chamber 1 was correct to unanimously find that the customary law avenue is open under the lex lata. In fact, the primary reason why I have chosen to make my humble request to appear before the Chamber as an amicus curiae was not to point out that the Security Council avenue is perfectly sound as a matter of existing law. Instead, I have requested to appear in order to state my reasons why there is another legal avenue, which is also legally sound, but which is more legitimate. More legitimate because more in line with fundamental aspiration of an equal enforcement of the law. And I firmly believe that legitimacy is the most precious currency for international criminal justice and its quintessential expressive function to the world. Fear not, Your Honors, I shall not now rehearse my arguments in support of the customary law avenue. I shall also not summarize the flaws which I believe to have detected in most of the counter-arguments that we have heard in the past days. Instead, in order to be truthful to my role as amicus curiae, I wish clearly to acknowledge the two central arguments against the customary law avenue, and I wish to focus on them. To the first such argument, Judge Morrison alluded in the one single question I recall him asking during the hearing. And Mr. Robinson made the argument. The argument is based on the principle that nobody can transfer more rights than he possesses himself. If the counter-argument holds, which starts from there, a customary international criminal court exception cannot even exist at the vertical level of the court's exercise of jurisdiction. Article 27(2) of the ICC statute would then not be reflective of customary international law, even if it's in its vertical dimension. There can be no doubt that this counter-argument deserves the closest analysis. And yet, such analysis reveals that the argument does not fully appreciate the ultimate basis of the ICC's jurisdiction. More specifically, the argument is based on the idea that the ICC's jurisdiction results from a delegation of national criminal jurisdiction. Under this delegation theory, the basis of the ICC's jurisdiction is no different from that of a bilateral criminal court, which, say, Germany and France would establish tomorrow. But here, common sense alone makes us pause. Is there really no qualitative difference between the ICC and the French-German criminal court? I am convinced there indeed is such a qualitative difference. The difference results from the fact that the entire evolution of international criminal law has been inspired by the idea that war crimes are so horrendous that they affect the international community as a whole. There is a jus puniendi that transcends state sovereignty and instead resides in the international community itself. Already the Nuremberg judgment, which was then unanimously affirmed by the General Assembly, articulates the essence of this idea. We can articulate this very idea with greater precision since the concept of international community has fully crystallized as a legal concept. A crystallization which is apparent from the passage of the ICJ's judgment in Barcelona traction, which we have looked at. If states have recognized through their practice and opinio juris that such a jus puniendi of the international community exists, they must be entitled to provide this community with an organ, no other than an international criminal court, to enforce it. Certainly, Germany and France cannot claim to be entitled to do that on their own. This would be a hegemonic hostage-taking of the idea of the international community. But states must be entitled to initiate a treaty negotiation process which is open to universal participation and guided by universally accepted human rights standards. All this with the transparently stated goal to provide the international community with a permanent judicial organs to enforce this jus puniendi. If it were otherwise, the only way to provide the international community with such organ, to enforce the jus puniendi, would be by virtue of an ad hoc decision of the 15 members of the UN Security Council. I respectfully submit that the line of reasoning which I've just set out offers the most plausible explanation of the international court international court's recognition of the customary international criminal court exception in the arrest warrant case. This reasoning explains why the ICJ has not limited this exception to Security Council-based ad hoc tribunals. And the same reasoning explains why the ICJ has not referred to international criminal courts without qualification, but only to certain international criminal courts, including this court. This reasoning, therefore, allows us not to dismiss a key passage in a judgment of the principal judicial organ of the United Nations as an essentially unreflected statement made in passing. Instead, it explains why the ICJ has correctly found in paragraph 61 of the arrest warrants case that customary international law contains an international criminal court exception to the immunity ratione personae, an exception which includes this court. To conclude on the first central counter-argument, the ICC's jurisdiction is not fully understood on the basis of a delegation of powers theory. I therefore urge the appeals chamber not to belittle in its decision the basic underpinnings of its own jurisdiction and not to make this court indistinguishable from a transnational criminal court where a group of states have bundled their forces to pursue their joint national interests in the prosecution of cross-border crimes. The second central counter-argument concerns the inclusion of the cooperation level into the international criminal law exception. The argument has been voiced clearly and loudly during the week. The execution of an ICC request for arrest and surrender is believed to constitute an exercise of foreign national criminal proceedings. And this counter-argument, again, deserves the closest possible attention. And I wish to make one point very clear, to present the counter-argument as sharply as possible. The organs of the state party who physically execute a request issued by the ICC remain, at least in my humble view, legally organs of that state party in the sense of the customary international law of attribution. So the ultimate question is whether this technical legal perspective of attribution should answer the matter. As you know, I am convinced that it should not. Instead, I have explained why I believe that the proper delineation between the customary immunity rule for national criminal proceedings and the International Criminal Court exception to it should be guided by the purposes underlying the rule on the one hand and the exception on the other. As I have set out to you, Your Honors, why on the basis of such an approach the cooperation level must come within the International Criminal Court exception. Now, I can almost see Mr. Wood saying, "Caught you." That's deduction. And we don't do deduction when we identify rules of customary international law. My answer to this hypothetical criticism would be, well, not quite. If we become so deduction adverse in international law that we do not even allow deduction when we have to delineate an existing rule from an existing exception to this rule, we shall end up producing legal voids. Is this a call from the ivory tower of academia? Your Honors, my answer is again, well, not quite. Let me show you why. During this week, we have spoken a lot about paragraph 61 of the arrest warrants case. But let us now look for a moment on paragraphs 53 and 54 of the same judgment. Here the court explains why the customary law rule on immunity ratione personae extends to sitting foreign ministers. That is the core of the ratio decidendi of that case. Here the court does not cite a single case or any other piece of state practice which would have been directly relevant. The court rather proceeds with a deductive, a functional, or if you wish, a purposive ascertainment of the content of the rule. This was not a judicial aberration. In fact, I believe it was fully justified, and it has been accepted as such by nobody less than the International Law Commission. This concludes my argument in support of the customary law avenue. Now, Though legally correct, the customary law avenue neither is obvious nor is it uncontroversial. I have never pretended that it is, and I shall not do so now. Therefore, if the Chamber finds merit in my humble submissions, it will nevertheless most carefully ponder whether it should not better proceed through the avenue which to me is almost obviously available, that is the Security Council avenue. If the Chamber will eventually heed the prosecution's call for judicial economy, then I can only hope that it will leave the customary law avenue open for a fresh consideration at another occasion. I respectfully remind the Chamber of my suggestion to speak of the displacement of any possible immunity of President al-Bashir when proceeding through the Security Council avenue. I shall not say anything more on the Security Council avenue. Instead, Your Honours, please allow me to conclude my modest contribution to this hearing by a few observations on Article 87.7 and on the third ground of appeal. What is the purpose of a referral under Article 87.7? The key purpose, I should think, is to allow the body to which the matter is referred to take measures which may help ending the violation of the duty to cooperate, or, where the violation is complete, as in our case, which help preventing its repetition in the future. I find much merit in the prosecution's proposition that there might also be a broader purpose, namely that to allow the bodies concerned to take measures which, under the circumstances, seem useful to enhance cooperation more generally. But I do not think the third ground of this appeal turns on any such possible broader purpose. For the core consideration of non-repetition by Jordan is certainly relevant in the present case in view of President al-Bashir's persistent inclination to travel. Now, is there a sufficiently powerful countervailing consideration? I believe there indeed is. And that is the serious legal controversy that has been with us since too many years now. Jordan holds a legal view that I'm completely convinced is incorrect on several important fronts. But I, of course, recognize that there has been a serious legal debate on the matter since many years now. And the fact that a number of highly distinguished colleagues present in this room defend Jordan's position confirms the persistence of this serious legal debate. And also, I believe that Jordan deserves credit. Credit for having been engaging constructively in the endeavor to allow this chamber now to authoritatively clarify the legal situation in a reasoned manner. I concur with the Darrell Robinson group. What is really needed after this debate is precisely that, the authoritative clarification of the legal situation by this august chamber. Once such clarification has happened, however, this court has done everything it possibly could. The court will then be unreservedly, and I repeat, unreservedly entitled to expect from Jordan, as from all other state parties, to act according to its authoritative clarification of the law. May the content of the letter please Jordan and other state parties or not.
5 more minutes, Counsel.
It will be just one sentence. But let me emphasize that final sentence to make a last point. If state parties are not prepared to show such basic loyalty vis-à-vis this court, the ambitious undertaking vested by humanity with so much hope of establishing a permanent international criminal court to enforce the jus puniendi of the international community cannot succeed. I wish to thank you, Your Honors, for giving me what I consider the immense privilege to listen to me during this week.
Thank you very much, Mr. Kress. The privilege goes both ways in relation to all of you. Mr. Tanzi, your turn, please.
Merci, Monsieur le Président, de me donner à nouveau la parole pour présenter mes observations finales à toutes nos discussions. Les très intéressantes discussions de ces jours ont révélé l'existence d'opinions divergentes, même parmi les amici curiae, sur celle qui est la question centrale dans l'affaire en cause. Si la Jordanie avait ou non l'obligation d'arrêter et de remettre M. al-Bashir, qui était destinataire d'un mandat d'arrêt de la Cour pour des crimes qu'il est accusé par la Cour d'avoir commis dans la situation du Darfour. Cette obligation a été déterminée par la Chambre préliminaire 2 dans le premier dispositif de sa décision qui est sous appel. Cette question empiète naturellement sur celle du renvoi de la Jordanie à l'Assemblée des États parties au Conseil de sécurité décidé par la Chambre préliminaire en faisant recours à son pouvoir discrétionnaire en cette matière. Tout le monde me semble d'accord ici que pour la solution de ces questions, les suivantes règles internationales sont pertinentes. La règle coutumière sur l'immunité personnelle des chefs d'État, les dispositions de la résolution 1593 du Conseil de sécurité et certaines règles du statut de Rome. Pour un des amici curiae, une norme de nature coutumière, on l'a à peine entendu, prévoyant le ius puniendi de la communauté internationale qui s'occupe des crimes de pertinence internationale, et ius puniendi qui serait mis dans les mains de la Cour pénale internationale, ferait exception à la règle coutumière sur l'humanité et représenterait donc la panacée pour se débrouiller dans cette affaire. Je tiens tout de suite à observer que la Chambre d'appel, qui selon le principe iura novit curia, en disant le droit sur la question de savoir si la Jordanie avait ou non l'obligation en cause, pourra aussi se poser la question si une telle exception coutumière existe. Les moyens d'appel concernent en fait le dispositif et, selon mon opinion, laissent la Chambre d'appel souveraine dans l'argumentation à suivre pour en arriver au résultat. Mais même si la Chambre d'appel arrivait à ce résultat affirmant l'existence d'une telle règle d'exception, elle ne pourra éviter, à mon avis, de prendre en considération les règles conventionnelles et subconventionnelles qui, selon les deux parties, sont pertinentes dans cette affaire et desquelles les parties donnent une interprétation divergente. Mes observations auront trait seulement à l'application donc de ces règles conventionnelles et subconventionnelles. La règle coutumière sur l'immunité personnelle des chefs d'État. La divergence fondamentale est celle de savoir si elle exprime ou non le principe fondamental de l'égalité souveraine des États. Et donc, si une résolution du Conseil de sécurité prise sur la base du chapitre 5 puisse ou non faire exception. Je ne vais pas répéter les arguments qui me portent à considérer qu'elle n'exprime pas ce principe fondamental, mais qui, même si c'était le cas, une décision du Conseil de sécurité selon le chapitre 7 peut bien empiéter sur les deux principes au titre d'une valeur et d'un intérêt encore plus important, celui du maintien de la paix internationale. Même si la Jordanie et les organisations que la Chambre a invitées à prendre position sur l'affaire en cause, ainsi que quelques amici curiae, considèrent que la dite règle coutumière exprimerait le principe de souveraineté et aurait même une valeur absolue, de façon contradictoire, selon moi, ils admettent que tant l'État peut y renoncer et que le Conseil de sécurité aurait pu le faire s'il l'avait fait expressément. Sur cet aspect, il y a d'ailleurs une prise de position autorisée de la Cour internationale, ce dernier État n'étant pas parti au statut, en tout cas en raison de l'exception dont à l'article 98 si le statut s'appliquait. Toujours selon la Jordanie, l'article 27 ne s'appliquerait même pas en vertu de la résolution du Conseil de sécurité parce que le Conseil aurait dû le dire expressément et ne l'a pas fait. On ne peut pas le déduire par implication nécessaire, selon la Jordanie à nouveau. Permettez-moi, honorable juge, de vous rappeler la position exprimée dans l'écriture du 18 juin et réitérée pour moi ici. C'est un fait que le Soudan n'est pas parti au statut de Rome et dans le droit international n'existe pas, je suis d'accord avec la Jordanie, un statut de quasi-État ou d'État analogue aux États partis. Mais sur cet aspect, on doit faire application conjointe d'un côté de la disposition de l'article 13b, y compris le chapeau de l'article 13, et de l'autre de la résolution du Conseil de sécurité. Cette résolution, au paragraphe 1, renvoie la situation du Darfour au procureur de la Cour et donc, d'un côté, établit la juridiction de cette Chambre sur telle situation et de l'autre, actionne la procédure d'investigation et poursuite devant la Cour. J'ajoute qu'une telle interprétation de la fonction du renvoi est presque unanime dans la doctrine, contre une position hautement minoritaire qui considère que la décision du Conseil n'établit pas telle juridiction parce qu'elle résulterait déjà du statut. Selon notre position, le Conseil, par le renvoi à la Cour d'une situation, utilise une technique qui est très fréquente dans sa pratique, l'incorporation dans sa décision, quelquefois explicite, quelquefois par implication nécessaire, comme dans le cas d'espèces, de règles du droit international provenant d'autres sources. Ce qui est le cas ici, les conventions de Genève sont très fréquemment incorporées par implication ou par référence explicite par le Conseil de sécurité dans ses résolutions. Mais ici, l'incorporation par implication nécessaire est bien plus évidente en raison du fait que le renvoi de la situation est prévu par le même instrument objet de telle incorporation. Et donc, l'implication nécessaire résulte de l'application conjointe, article 13, chapeau et résolution B et résolution du Conseil. Et la résolution incorpore le statut dans ses règles substantielles et procédurales qui permettent à la Cour de conduire les enquêtes et poursuites et de soumettre au procès les éventuels accusés des crimes qui ont été commis. Donc l'article 27 compris. Et l'incorporation concerne les règles relatives à la conduite du procès, etc. Dans la partie 5 du statut dédiée aux enquêtes et poursuites, on trouve aussi l'article 58 relatif au mandat d'arrêt et l'article 59 relatif à la procédure d'arrestation dans l'état de détention. L'incorporation ne concerne pas les règles relatives à la governance, comme le professeur Robinson l'a indiqué. L'incorporation ne peut que concerner aussi les règles sur la coopération des États avec la Cour, sans lesquelles toutes les activités dont au chapitre précédent ne pourraient pas être déployées. Ces règles sont prévues dans une partie séparée, partie 9, parce qu'ils ne concernent pas l'exercice de la compétence par la Cour, mais seulement la coopération des États avec cet exercice. Cette partie contient, la partie 9 contient aussi l'article 88, qui est donc aussi incorporé par la résolution. Une objection de la Jordanie touche aussi ma position. Si aussi les règles du statut sur l'obligation de la coopération s'appliquent par implication nécessaire, pourquoi, s'est demandé la Jordanie hier ou peut-être il y a 2 jours, pourquoi au paragraphe 2 en décider expressément au lieu de dire simplement que le Soudan doit coopérer pleinement? Réponse, selon moi. L'applicabilité au Soudan du statut de Rome dérive de l'application conjointe de 2 actes internationaux qui doivent tous les 2 être obligatoires pour la Jordanie et le Soudan, en particulier pour le Soudan. Si l'obligation de reconnaître la juridiction de la Cour sur la situation du Darfour dérive du statut et de la résolution, cela comporte par implication nécessaire l'incorporation et l'application de toutes les règles nécessaires. Et donc, lié à cet exercice. Et la résolution doit dire clairement que sur la coopération pleine du Soudan, le Conseil décide. Autrement, l'application conjointe n'est pas possible. Tant plus que l'article 86 s'adresse aux États partis, et donc sur les États qui ne sont pas partis. En particulier le Soudan, parce que les autres sont exclus par les faits obligatoires. Il faut que le Conseil de sécurité les dit expressément, décide au paragraphe 2. Le paragraphe 2 s'occupe aussi, naturellement, de cette coopération des États qui ne sont pas partis au statut et qui ne sont pas impliqués comme le Soudan dans la situation, et par une formulation différente. De cela, on s'est occupé. J'ai fait des observations sur cela et dans les réponses sous-groupe B. Si j'ai encore un peu de temps, je voudrais m'arrêter un petit plus sur cette question de la coopération en matière d'exécution de mandats d'arrêt et de remise. L'État, en exécutant la demande, plutôt qu'agir par délégation de la Cour, qui n'a pas à disposition une police judiciaire, et donc ne peut pas déléguer l'exécution par la police des mandats d'arrêt et de remise, elle a besoin seulement d'utiliser les moyens coercitifs qui sont à la disposition seulement des États. Dans sa demande d'arrestation et de remise, la Cour, par ailleurs, ne demande pas à l'État d'exercer sa juridiction. Et donc, je ne peux pas du tout être d'accord avec la revendication de la Jordanie qu'ici, c'est la juridiction nationale qui décide. Le mandat d'arrêt a été décidé par la Cour. La demande d'exécution du mandat d'arrêt est décidée par la Cour selon ses dispositions. La Cour demande simplement à l'État, selon l'article 58 ou 59, d'exécuter cette demande. L'article 59 est particulièrement illuminant au propos du fait que la juridiction interne ne s'occupe du tout de l'immunité dont un agent d'État pourrait jouir. L'article 59 prévoit en fait une décision, un contrôle par la juridiction interne, donc l'exercice d'une juridiction de cognition, mais seulement dans un but très limité. La juridiction interne pourra s'occuper seulement de vérifier que le mandat vise bien cette personne, que celle-ci est arrêtée selon la procédure régulière et que ses droits ont été respectés. Et l'immunité n'est pas un droit de l'accusé. Elle ne s'occupe pas de la question de l'exécution du mandat d'arrêt et de remise de l'accusé, dont s'occupera la police judiciaire de l'État. Donc, l'obligation de coopération, dont à l'article, au statut, à l'article 86 du statut, concerne tous les aspects de l'activité de la Cour. Toutes les activités qu'elle a déployées selon la juridiction de cognition et selon la juridiction d'exécution à partir du moment de la réception par la Cour d'une simple notitia criminis jusqu'au transfert d'un condamné dans une prison mise à la disposition d'un État ou à la libération de l'innocent. L'enquête sur un suspect comme la poursuite d'un accusé qui comprend tant l'émanation des mandats d'arrêt que la soumission de l'accusé au procès en présence, pour autant que les États coopèrent à son arrestation et à sa remise, représentent toutes des phases de l'exercice de la juridiction de la Cour, qui sont d'ailleurs indiquées de façon synthétique par les deux mots « investigation » et « poursuite » dans le titre du chapitre 5, si je ne me trompe pas. Donc, poursuite ne signifie absolument pas seulement exercice d'une juridiction de cognition. Le fait de dire que dans l'article 86 ne rentrerait pas l'exécution de la demande d'arrestation et de remise, peut-être qu'on pense que cela ne rentre pas parce que la Cour n'est pas dotée d'une police judiciaire. Et c'est cette faiblesse structurelle de la Cour qui dépend seulement du fait que les États sont dotés d'un bras armé et pas la Cour, comporte justement l'obligation de la coopération par les États, sans laquelle la Cour, je l'ai déjà répété beaucoup de fois, pardonnez-moi, ne peut pas réaliser, expliquer son activité. Une telle reconstruction des dispositions statutaires en matière de coopération trouve aussi une confirmation dans les dispositions qui prévoient les conséquences de la violation d'une demande de coopération de la part de la Cour. Comme Kelsen nous a enseigné, la sanction dans le sens large du terme fait la norme. Donc, la prévision dans le statut de certaines conséquences à la violation de l'obligation de coopération, y compris la prévision expresse de certaines conséquences à l'inexécution d'une demande d'arrestation et de remise, confirme l'obligation de la coopération en cette phase aussi de l'activité de la Cour. Tout en n'étant plus possible d'obtenir la coopération de la Jordanie dans le cas sub iudice, il n'est pas à écarter la possibilité que la Cour se retrouve dans la situation de devoir adresser une demande de remise de l'accusé al-Bashir au même État ou à d'autres États, comme il est d'ailleurs déjà arrivé. Et la différence fondamentale par rapport à la situation de l'Afrique du Sud, prise en considération par la Chambre préliminaire, et qu'une décision de la Cour suprême de ce pays dit que l'obligation d'arrêter et de remettre à la Cour s'imposait et devra s'imposer si al-Bashir va retourner en Afrique du Sud. Pourquoi la Chambre aurait-elle dû décider le renvoi de l'Afrique du Sud dans un but de déterrence pour le futur, quand c'est la Cour suprême qui l'a déjà dit?
Mr. Tazi, you have about 4 more minutes.
Oh, sorry. Hein? Parfait. Merci, Monsieur le Président. Et est-ce qu'on peut penser que le gouvernement peut s'en passer du respect d'une décision de la Cour suprême? Le gouvernement sud-africain, naturellement. Donc, la Chambre préliminaire n'est pas imputable un abus de droit pour manque de neutralité. En vue de ces possibilités, un renvoi actuel de la Jordanie à l'Assemblée des États partis au Conseil de sécurité pourrait opérer comme dissuasion d'une future inexécution par un État d'une demande d'arrestation et remise de M. al-Bashir ou d'autres accusés aussi dans des situations autres que celles du Darfour. Le fait qu'aucune conséquence ne suit à des violations continues et persistantes du statut de la part des États obligés par cet important instrument international ne pourra que porter à une érosion graduelle de la crédibilité de la Cour et de son autorité formelle et morale jusqu'à la faillite définitive, selon l'attente de certains gouvernements, mais certainement pas selon l'attente des milliers et milliers de victimes de crimes affreux, lesquels voient dans cette institution la seule possibilité de connaître la vérité judiciaire et de regagner un peu de leur dignité perdue. Merci de votre attention.
Thank you very much, Professor Tazi. Now, Mr. O'Keefe.
Your Honours, the rationale of the adversarial system of legal proceedings is that through the back and forth, the claim and counterclaim, the cut and thrust between the parties, the more persuasive of the two arguments is revealed to the judge. It is an ancient system, but it is also very modern, perhaps postmodern, in that it acknowledges that, in the realm of epistemology as distinct from faith, the best approximation of the truth for which we can hope is the more, or when others are involved, most persuasive argument. The drawback of this system is that, except for tactical concessions, it is impossible for either of the two parties, each briefed by a client or employer, to whom it owes a professional duty, to throw up its hands and publicly acknowledge the superior persuasiveness of the opposing argument. No such professional duty, however, constrains the professor of law, acting as the professor of law, and what is more, appearing as amicus curiae, a friend of the court. Indeed, the duty of the professor of law is to be a seeker of and witness to the more persuasive argument. And the duty of the amicus curiae, at least of the amicus curiae appearing unpaid and indeed at his or her expense, although hopeful of an increase in book sales with the attendant 0.5% royalties, is to draw the court's attention to that more persuasive argument. What may constrain the professor of law is ego, or at least a sentimental attachment to a firmly held personal view. But it can be exciting, bracing, and a satisfying, perhaps self-congratulatory reminder of the vocation of the professor of law to concede that an argument other than one's own, what in intellectual terms may even be seen as an opposing argument, is the more persuasive. In the course of these written and oral proceedings, which do great honour to this court, to you, Your Honours, and to you, Mr. President, in their sincere pursuit of the more persuasive argument, through the invitation to a range of natural and legal persons to participate in assisting the court as amici curiae, I have twice had cause fundamentally to reassess what was a firmly, indeed passionately held personal view, although I am sure all present will struggle to believe that I hold personal views firmly or passionately. The first time was in relation to the meaning in Article 98(1) of the Rome Statute of third state, the doubtfulness of my position on which had already, 2 years or so ago, been kindly alerted to me in a public blog exchange with my friend Professor Robinson. I had always taken the view that the meaning of third state in Article 98(1) accorded with the meaning given to it in Article 2(1)b of the Vienna Convention of the Law of Treaties, namely a state not party to the treaty. But, and although the question is not as clear-cut as many would think, a point on which I humbly invite scholars to read paragraph 8 of my request to submit observations on the merits of the present case, while preparing my eventual written observation on the merits, I was compelled by my professional and indeed personal commitment to the more persuasive argument to concede the point and to accept that third state in Article 98(1) meant simply a state, non-party and party alike, other than the state party to which the court's request for arrest and surrender was directed. The second such occasion, which was consummated last night, as it were, was in relation to my formerly firmly and indeed passionately held view that although Article 27(2) of the Rome Statute manifestly had and has no application to arrest and criminal proceedings at the national level for surrender of a person to the court by a state party, the states parties to the Rome Statute nonetheless mutually consented to the surrender of each other's state officials to the court through their agreement to the unqualified terms of the second sentence of Article 98(1) of the statute, the obligation of arrest and surrender to the court of a person the subject of the court's request to a state party for arrest and surrender. While preparing paragraphs 4 to 6 of my written observation on the merits, the realization had dawned on me that I was suggesting that implied consent to the waiver of immunity and inviolability, indeed to the abrogation of immunity and inviolability by another state party, was sufficient, contrary to the usual requirement in international law that waiver be explicit, a point I freely conceded to the court yesterday. I nonetheless remain sufficiently persuaded that it was understood by the states parties that they would arrest and surrender each other's officials. Under a withering barrage of blows yesterday from my dear friend and sparring partner Professor Kress, to whose arguments, presentational skills, passion and unfailing courtesy throughout these proceedings I pay sincere honour, and after reflection on the matter last night, after enjoying a tasty Belgian beer called Affligem, which turned my mind to affliction, and ultimately, as one raised in the Catholic faith, to repentance, I came to the conclusion that my acceptance of a state party's implied consent to the waiver, indeed the abrogation by other states parties of the immunity and inviolability owed to it under international law in respect of its state officials, was the less persuasive of the two arguments. This led me, as foreshadowed yesterday, to an unavoidable conclusion. If this were so, if Article 89(1) did not amount to the waiver by states parties of the immunity and inviolability owed to them by other states parties in respect of their officials, the choice presented to the court was and is stark. On the one side is what I understand to be the implicit position of Jordan, that the effect of Article 98(1) of the Rome Statute, the provision on which this case turns, is that the arrest and surrender to the court by a state party of an official, even of another state party, in respect of whom the first state party owes obligations under international law to accord inviolability and immunity can be effected only if the court first obtains the explicit waiver by the second state party of that immunity and inviolability, a position the teleological justification for which would be that the state party may always, on request from the court, itself be required to arrest and surrender the official to the court, or to waive that official's inviolability and immunity from the criminal jurisdiction of the other state. On the other side is the position of the prosecutor, that Article 27(2) of the statute has the effect at the national level in relation to arrest by a requested state party's police and to surrender proceedings before that requested state's party's courts of a waiver by the state party whose official it is of the immunity and inviolability owed to it under international law by the requested state party. In this regard, I have to say that I was astonished twice to hear Mr. Raston blithely assert that the vertical effect of Article 27(2) appeared to be agreed on between the parties and among all other participants, by which I take him to refer to the theory that as among states parties themselves, Article 27(2) has the effect of rendering inapplicable in the context of arrest and surrender at the national level the immunity and inviolability ratione personae under international law of a head of state. Unless I am embarrassingly mistaken, in which case I ask counsel for Jordan in due course to correct me, this is precisely not accepted, and now I believe persuasively so, by Jordan, which maintains, in my understanding, that even as among states parties, Article 27(2) has no so-called vertical effect. Mr. President, Your Honours, as a professor of international law and a true friend of the court, I too am unable to accept the prosecutor's argument, and I never have been able to accept the prosecutor's argument. As a matter of treaty interpretation, and with the greatest and sincerest of respect to the labour and ingenuity of counsel for the prosecutor, I find the claim that Article 27(2) of the statute applies also to the national level utterly implausible. The ordinary meaning of Article 27(2) is that immunity poses no bar to the prosecution of a state official, whether of a state party or a state not party to the statute, before the court itself, after that official has been arrested and surrendered to the court. The context of Article 27(2) supports this ordinary meaning. The other provisions of the Rome Statute and the statute's overall structure, to which paragraph 97 of the judgment of the International Court of Justice in application of the Interim Accord of 13th September 1995 instructs us to have regard, are clear. Indeed, except in the eyes of those who will not see, self-evident. Part 3 of the statute, all of the other provisions of which specify and are taken to specify by the state's parties the general principles of criminal law applicable in proceedings before the court itself, is restricted to general principles of criminal law applicable in proceedings before the court itself. Part 9 of the statute, as its title indicates, regulates international cooperation and judicial assistance by states parties to the court. There are other provisions sprinkled throughout. My point here goes rather to Part 3 than to Part 9. Were Article 27(2) as a matter of treaty interpretation to extend to arrest and surrender proceedings at the national level, it would be the only provision of the whole of Part 3 to do so. this is simply not the more persuasive argument. Nor can the consequences of this conclusion be obviated by recourse to the patent fiction that the arrest of a person by a state's party's own police and surrender proceedings against that person before a state's party's own courts do not amount to the exercise by that state party of its own criminal jurisdiction, enforcement and adjudicative. Horizontal, vertical or diagonal, how can the arrest of a person by a state's party's own police and surrender proceedings against that person by a state's party's own courts not amount to the exercise by that state party of its own criminal jurisdiction? If the theory of the vertical effect of Article 27.2 of the statute is correct, what purpose does Article 98 serve in the statute? Why does Article 88 provide that states parties shall ensure that there are procedures available under their national law for all forms of cooperation which are specified under this part? Why does Article 90 take into account competing requests to the requested state and for the surrender of a person, and paragraph 6 of Article 90 ultimately permit the requested state, in the event of a competing request from a state not party to the statute, to which it owes an international obligation to extradite the person, to give priority to the request from the non-party state? At this point, and again with respect, the position of the prosecutor strains credulity to breaking point. The prosecutor's position exists in the transcendent realm of metaphysics. It is an act of faith, not a proposition of law. The response of the prosecutor to all this is to resort to the Casasian metaphor of the giant with, I thought, no arms, but perhaps it's no legs, to say that Jordan's position would render the court powerless and therefore simply cannot be accepted. This is to elevate contingent fact above the rule of law. The law says what it says and must be applied faithfully by a court of law. It is on the law that the states parties to the statute agree. The agreement, or dare I use the C word in this court, consent of the states parties, is the bedrock of the law of treaties. Indeed, whether we like it or not, the agreement or consent of states remains the bedrock of the international legal order. Try telling the People's Republic of China, the Russian Federation, and the United States of America, all of them states not party to the statute, all of them involved in the adoption of Security Council Resolution 1593, that consent does not matter. As it is, who says that Jordan's position would amputate the court's limbs? As Article 86 provides, a state party is bound to cooperate fully with the court. As Article 89.1 stipulates unambiguously, a state party is obliged